Welcome everyone to our Payday and Title Loan class at the Legal Aid Center of Southern Nevada. So the purpose of the class is to learn the basics of short-term high-interest loans such as payday loans and title loans. We're also going to learn what lenders are required to do and what things lenders can't do under the law. And also, we hope that you'll leave this class with an understanding of your rights and responsibilities as a consumer. So let's just jump right into it. What are short-term loans? So typically, these are small dollar loans with very high interest rates. Currently, unfortunately, there is no interest rate cap in Nevada, so these interest rates can be very high, sometimes upwards of 5 and 6 and 700%. There are 4 types of short-term loans: deferred deposit, high interest installment, and title loans. The ones we see most commonly are the high interest loans, and we'll talk about that in some more depth in the presentation. So these loans are not credit-based, meaning that there's a higher risk that the borrower won't pay them back. So lenders in Nevada will lend to consumers who may have bad credit or no credit, and because these are kind of risky for the lender, to offset that risk and make these loans extremely profitable for businesses to offer, the interest rates also tend to be extremely high. So short-term loans are really, as the name indicates, they're meant to be a short-term, one-time fix for an emergency situation. So for example, if your car breaks down or you're short on rent, or just some emergency situation that you don't anticipate comes up. However, oftentimes they're used to cover ordinary recurring expenses such as monthly rent, on a month-to-month basis, utilities, groceries, credit card bills. And this can trap someone in the cycle of debt, which we'll talk about later in the presentation. One last thing for short-term loans that's important to remember: the length of the loan period depends on the type and terms of the loan, which we'll get into a little bit later. So how do short-term loans work? Typically, there's no credit check associated with these type of loans. Like with other loans, they're considered high-risk loans, which allows people with poor or no credit to get them easily. However, there are protections. So Nevada law does require lenders to verify the borrower's ability to repay that loan. For unsecured loans, meaning not tied to something like a house or to a vehicle, the borrower has to provide proof of income with such documents as paycheck stubs, bank statements, and other documentation. So the monthly payment of a loan must not exceed 25% of the borrower's gross monthly income. So that's gross monthly income is before taxes. The lender also needs to consider, before making a loan, such things as the borrower's other financial obligations. So the borrower may have a lot of other debt, and taking out this loan would cause the borrower to exceed that 25%. So for title loans, which are secured by the title of someone's vehicle, there's no minimum income requirement or monthly payment restriction. However, the loan amount can't be more than the fair market value of the vehicle. So there is a constraint on it. And lenders are still required to determine if the borrower has the ability to repay the loan. So they'll look at things like paycheck stubs, bank statements, and other documentation. So once the lender approves the borrower, everything goes according to plan, the borrower will sign all the documents, and sometimes this is done electronically at the store, regarding how much the borrower is taking, the interest rate, and the total amount the borrower will have paid at the end of the loan. That's the total of payments. So once everything is approved, once the borrower signs, the borrower will receive cash from the lender. Now the borrower is required to make payments as written in the contract. So whether they've agreed to make one payment to pay back the loan or multiple payments, which is more common, the due dates are usually the same as the day that the borrower gets their paycheck. So if you see 6 payments, it could be every 2 weeks when the borrower gets paid by their employer. Once the loan is paid in full, there's nothing more the borrower has to do. So the lender's obligations and the borrower's obligations have come to an end. But in reality, what we see is the borrowers will often take another loan to pay bills that they can't pay due to the high cost of the previous loan. So this is how many people get trapped in the loan cycle, or what we call the debt treadmill, because they're not just paying back the amount that they borrow, they're paying it back with interest. And the high interest payments may cause them to fall behind on other bills, which cause them to take out more payday and title loans, which trap them in the cycle of debt. So if the borrower does not pay back the loan, either because they can't afford it or something else goes wrong, it will go into default. And there are guidelines that the lenders have to follow once a loan is in default, which we'll talk about later in the presentation. So the statewide database, this is a great consumer protection. So NRS 604A.303 subsection 1, that's the part of the Nevada revised statutes where this statewide database is codified. It requires the Nevada Financial Institutions Division to maintain a statewide database of short-term loans. And so this database may include whether a customer has a deferred deposit, title, or high interest loan outstanding with more than one licensee. And licensee refers to a business that's licensed by the Financial Institutions Division to be a lender. It also includes whether a customer has had such a loan outstanding with one or more licensees within the 30 days immediately preceding the making of the loan, and whether a customer has had a total of 3 or more such loans outstanding with one or more licensees within the 6 months immediately preceding the making of the loan. So all of this goes into the database, and it allows the licensee, the lender, to comply with these ability to repay statutes like we talked about in the previous slides. So before making a new deferred deposit or high interest loan, the licensee must check this database to ensure that the new loan in combination with any other outstanding loans does not equal 25%. It does not exceed 25% of the customer's expected gross monthly income. So this is a way, it's an enforcement mechanism. So really the lender must check the database and see all of the other outstanding loan obligations of the consumer so that taking out a new loan does not cause them to exceed 25% of their expected gross monthly income. So after making a new loan, the licensee then has to update the database with information on that loan. So if the borrower goes to another licensee and tries to take out a loan and they're already up to that 25%, the licensee should not allow them to take out a new loan. So last thing on the statewide database, state regulations allow a $3 fee to be passed on to the consumer for checking the database. So this is just to compensate the lender for having to check the database. Sometimes the borrower will see that $3 fee passed along to them. Okay, so this is the short-term loan cycle, also known as the debt treadmill. And we talked about this in an earlier slide when we talked about someone taking out a loan and then having to repay it with interest and then falling behind on other bills. So the short-term loan cycle, of course, will start with someone needing money, whether for an emergency expense or a recurring expense. They take out a loan. The person then gets their paycheck. They pay the loan and interest. And now, because of those high interest payments, and because they have to pay back this loan plus interest, now they start to fall behind on their bills. So of course, they'll need more money, take another loan, and so forth, and get trapped in the short-term loan cycle. And so our goal is to help people break out of this short-term loan cycle, to help them understand their rights as consumers, and to help them not to see that this can go on. The short-term loan cycle can really get people trapped. And a big purpose of this class is just education about this, so that people can hopefully avoid this short-term loan cycle or being trapped on the debt treadmill. So these are just a few examples of the way that some of the lenders are advertising in our community. So Title Max, get the cash you need, lots of cash. Dollar Loan Center, making it seem very easy to get a loan. Signature loans, you can get up to $2,500 in minutes. Title loans, 80% of your vehicle's value. They also advertise to the Spanish-speaking community. This is an ad for Rapid Cash. Okay, let's go into a little bit more detail about the types of short-term loans. So we touched on this in an earlier slide, but we're going to go into a little bit more depth. So deferred deposit loans, these are your traditional payday loans. The borrower gets a loan to carry them through to the next payday. Usually this requires access to the borrower's bank account on their next payday. So someone will set up like an ACH transfer, just automatic payments from their bank on their next payday. That money goes from the bank to the lender, and the deferred deposit loan is paid off. Second type, which we see most commonly, are high interest loans. So these are any loan that charges an annual percentage rate of more than 40%. Sometimes they can be upwards of 400 and 500%. We've even seen them 999%, extremely high interest loans. These typically don't require access to the borrower's bank account, although the borrower can give access to the bank account similar to the deferred deposit loan. And these last for 90 days. Now we have high interest installment loans. These are kind of a variation of your high interest loan. So any loan that charges an annual percentage rate of less than 200% and has a term longer than 150 days. So this is what we think of as the typical dollar loan center loan. And finally, we have title loans. So these can be between 30 and 210 days. 210 days is the statutory maximum. And a title loan will require the borrower to secure the loan either by giving possession of the vehicle title, the physical title, or putting the lender's name on the title as a lien holder. And this in legalese is known as perfecting a security interest. So for a title loan, essentially you are giving your car's title in exchange for the loan as collateral for the loan. Okay, deferred deposit loans, and I put up at the top NRS 604A.501 and so forth. This is the part of the Nevada revised statutes where deferred deposit loans and are defined, and all of the laws relating to these loans are located. So as I mentioned, these are loans to be paid back in one lump sum, usually on the borrower's next payday. These are traditional payday loans as they were in advance that was paid back on the borrower's next payday. So traditionally, the borrower would give the lender a post-dated check or an authorization to withdraw from the borrower's bank account for the borrowed amount plus the associated fee. Once all of this is said and done, that the borrower is able to take out the loan, they've been approved, the lender will give cash to the borrower and will agree not to cash the check, this post-dated check, or withdraw the funds before the date written on the check, meaning that they'll wait till the person's payday in order to cash out that check. So often if the funds are not available that day, because there's been a delay in payroll, or maybe the person has been laid off and no longer has that employment, the lender will continue to attempt to withdraw the funds until they're available, resulting in numerous return check fees and overdraft charges by the borrower's bank. Hopefully this won't happen. This is just something to be aware of with these deferred deposit loans. Okay, now we have high interest loans. These are loans with an annual percentage rate, APR, of more than 40%. And often, as I mentioned, the interest rate is going to be well over 200% and can reach above 1,000% because in our state, we don't have an interest rate cap. These high interest loans may be paid back in one lump sum, similar to the deferred deposit loan, or in smaller payments over a longer period of time. So if they're single payment loans, the original loan term can exceed 35 days. For multi-payment loans, these are loans requiring more than one payment, the loan period can't go beyond 90 days. And each payment is an equal dollar amount. And this results in more predictability for the borrower. So here's an example of a rapid cash high interest loan agreement. Here you see here the federal truth in lending disclosures, and this comes from a federal law that requires that on all these types of contracts, they list the annual percentage rate, finance charge, amount financed, and total of payments. And the reason for this is that so consumers can compare the cost of credit. Can I get a cheaper loan, one that's not going to cost me so much, and one that has a lower annual percentage rate? This is really just for the consumer's information, so they can do some comparison shopping. So as you can see here, the annual percentage rate is almost 439%. The finance charge is the dollar amount that the credit will cost. The amount financed, that's the amount of the loan principal that you're taking out. And then the total of payments, what you're going to be paying to take out that amount financed. And that's with all of your interest. So as you can see here, this borrower had 6 payments, and the amount of the payments were equal to $99.94, and they were due on this person's payday. Okay, this is just an example of a calculator that we can use to check to make sure that the annual percentage rate is correct, the finance charge, total of payments, regular payments, and so forth. And so as you can see from the slide before, this is a calculation, and the calculations from the previous contract appear to be correct. Okay, now that we've talked about high interest loans, we're going to talk about a variation of high interest loans called high interest installment loans. And these are, the prime example would be dollar loan center loans. So these are loans with an annual percentage rate of less than 200% and terms longer than 150 days. So these loans are a type of deferred deposit or high interest loan. They're kind of a hybrid. So they require a payment at least once every 30 days, and interest does not accrue at the contract rate, meaning at that really high rate of interest, after the maturity date, so the date on which the loan is due to be repaid. Now, the lender has to comply with some more stringent requirements. They have to perform a credit check with a major consumer reporting agency, such as Equifax, Experian, or TransUnion. The lender must report information relating to the loan experience to major consumer reporting agencies. They also have to give the borrower the right to rescind or to retract or cancel that loan within 5 days without a fee if the person changes their mind. And they also have to participate in good faith with an accredited counseling agency. Important note about the high interest installment loans, the lender actually can't sue to collect on these loans if the borrower defaults. And as I mentioned, examples include the dollar loan center loans. Okay, here's an agreement, a dollar loan center installment loan agreement and disclosure statement. As you can see here, we have those the boxes to show the consumer so that they can compare the cost of credit. So we have the APR, the finance charge, the amount financed, and total of payments. And then as you can see here, unlike the high interest loan that I showed you a couple of slides ago, there are going to be a higher number of payments. So here we've got one payment of 101.13, and then we've got 30 more payments of 101.13, and then a final payment of 101.58. And again, the payments are going to be due presumably on that person's payday. Okay, last but not least, title loans. So these are loans with interest rates of more than 35%, often well above 300%. So again, that the interest rate is quite high. The borrower generally provides a vehicle title as security for the loan. This could be a paper title, or more often it would be the lender putting themselves as a lien holder electronically on the title. The original term of the loan can be 30 days if it's a single payment, or 210 days if it calls for installment payments. And so an interesting thing about title loans is that they're considered non-recourse loans under the law. So what this means is if the borrower defaults, they're unable to continue paying, the lender may only repossess the car and sell it. So that's the lender's only remedy is to take the vehicle, repossess the vehicle, and sell it. Now, if the sale of the vehicle isn't enough to pay off the loan, the lender can't go after the borrower for more. They're prohibited. So all they can do is repossess and sell that car. Now, in the more rare case, when the vehicle is not available for repossession because, it's been hidden, or it's been junked for parts or put into another jurisdiction, the lender then can file a lawsuit for a money judgment. But more commonly, if the borrower defaults and fails to repay, the lender's only remedy is going to be to repossess that vehicle and sell it. Okay, here's an example of a title loan agreement. This one is from TitleMax, a common title lender here in Nevada. So again, we have the federal truth in lending disclosures, the number of payments, and these are pretty much equal, again, due on the person's payday. And in exchange for this loan, the person would have to give their vehicle title or allow TitleMax to put themselves on the title as a lien holder until the loan is repaid. Okay, so what happens in the event that the borrower needs more time to pay? Something happens, maybe they weren't working as many shifts and they fall behind, or for whatever reason, they just need more time to pay. So what options are available to the borrower? So there are extensions, commonly known as refinancing. There are extended payment plans for certain types of loans, grace periods, and repayment plans. And this happens once the person is now in default, meaning that they've either missed a payment or they've come to the end of the loan term and they haven't made all the payments. So let's talk a little bit about extensions or quote unquote refinancing. So a lender may grant an extension to provide the borrower more time to pay. These extensions do not include grace periods. Grace periods are free, and they usually come at an additional cost. Lenders usually charge the full contract interest rate during this time. And so that's the high interest rate, that's up at the top in the Federal Truth in Lending Disclosure. So that's the APR. Lenders, something to be on the lookout for, lenders may try to quote unquote refinance an old loan by creating a new loan that surreptitiously or secretly extends the term of the old loan beyond the statutory limit. This is actually the subject of a Supreme Court case, Title Max versus the Financial Institutions Division. A deferred deposit loan can start out as a 35-day loan and may be extended up to 90 days after the date of the origination of the loan. A high-interest loan for 35 days may be extended up to 90 days after the date of the origination of the loan, and the 90-day loan is not available for extension. A title loan may begin as a 30-day loan and may be extended for up to 6 30-day periods for a total of 210 days. 210 is the maximum amount. A 210-day loan is not eligible for extension, so title lenders cannot extend it beyond that 210-day period. Okay, so extended payment plans are going to be for deferred deposit loans only, and deferred deposit loans, again, are those classic payday loans. So in order to take advantage of an extended repayment plan, the borrower must request that plan in writing prior to the due date of the loan if the borrower has not already entered into one in the last 12 months. So you get one chance in 12 months. Gives the borrower at least an additional 60 days to repay the loan with at least 4 payments. And importantly, the lender cannot charge any additional interest or fees beyond what's in the original contract. Okay, let's talk a little bit about grace periods. A lender may grant a grace period. Lenders are not required under the law to offer a grace period. However, they often do this to avoid the loan going into default, and this can be beneficial for the lender because the longer the loan is not in default, the longer they can charge that contract interest rate, that high interest rate. So important to note that grace periods need to absolutely be free. Lenders cannot charge additional interest or fees on the loan amount during the grace period. Grace period agreements, and this touches a little bit on our previous slide, where a borrower must pay additional interest are not allowed because they're not true grace periods, right? A grace period is supposed to be free. And they also unlawfully extend the loan period. So for example, for title loans beyond 210 days. So something that's a red flag is if a title lender is doing something that's going to extend that loan beyond 210 days, which is the statutory limit. Okay, default and repayment plans. So how do we define default under the law? I've mentioned that a few times, the word default. It has a specific definition under the law. So it's defined as failure to make a scheduled payment on or before the due date. So that's one definition. Or to pay the loan in full on or before the expiration of the loan period. So after default, when this default period is reached, the lender cannot sue or repossess a vehicle if it's a title loan without first giving a repayment plan option to the borrower. So in other words, in order for the lender to take some action once the borrower is in default, they have to give the option of a repayment plan. And that's subject to certain requirements under the law. So this option must be open for at least 30 days after the date of default. The plan must be for at least 90 days after the date of default. Something important to remember, repossession before default is a deceptive trade practice under Nevada law. Now, if that happens, you can feel free to come to the Legal Aid Center of Southern Nevada. We will discuss your legal options because that's a pretty serious offense, repossession before default. And the borrower here does have legal remedies. Also, with default and repayment plans, under these repayment plans, an initial payment of not more than 20% of the balance may be required. And finally, if the borrower defaults on one of these repayment plans or declines the repayment plan, in other words, they remain in default and they don't make any further payments, the lender may then take their legal remedies. They may sue the borrower or, in the case of a title loan, may repossess the vehicle. So now let's talk about debt collection after default. A common question is, what can a lender take from me or collect from me after I default on a loan? So that's a great question because they actually are limited on what they may collect. So after default, the lender may collect only any unpaid principal balance of the loan, any unpaid interest up to the date of default at the contract interest rate. They can also collect interest for a maximum of 90 days after the expiration of the loan period at a lower rate of interest. So this is prime plus 10%. And prime is a rate that's set by Nevada's largest bank, Bank of Nevada, and that rate is available on the website of the Bank of Nevada. Any return check fees that comply with the law. So these are all of the amounts that a lender may collect after default. And all of the above amounts cannot exceed the principal amount of the loan. So the lender, again, is limited on what it can collect after default. And again, for defaulted title loans, the lender's only remedy is to repossess and sell the vehicle. Again, these are considered non-recourse loans. All right, borrowers' rights. Borrowers do have some rights. They are somewhat limited here in Nevada. A borrower can rescind, otherwise known as cancel the loan, but they have to rescind at the same location before the close of business on the next business day after the loan was initiated. If the person changes their mind, they have to return the sum of the money equal to the face value of the loan or the original check from the lender to the borrower. And the lender cannot charge borrower a fee to rescind. So if the borrower changes their mind within the next business day and they want to go and rescind that loan, they can't be charged a fee. The borrower also has the right to make full and partial payments at any time before the loan due dates without an additional charge or fee. So prepaying a loan is not going to cause an additional fee to be incurred. Any authorization given in consideration, so checks, written authorizations to withdraw from a bank account, is considered void if paid early, which just makes sense. A lender must give the borrower an itemized receipt for each payment, so the borrower does have a right to demand that from the lender. Now, what happens if a check is returned for insufficient funds? The lender may charge a fee of not more than $25 for a return check. The lender may charge a maximum of 2 fees if a check is returned for insufficient funds. And now a lender may charge a maximum of 1 fee if the check is returned due to account closure. So for instance, if a person knows that they're going to default on one of these loans and they close their bank account, a maximum of 1 return check fee can be charged. Yeah. All right, so now that we've talked about short-term loans and borrowers' rights and lenders' responsibilities under Nevada law, I'd like to talk a little bit about the Fair Debt Collection Practices Act and how it relates to short-term lending. So what is the Fair Debt Collection Practices Act? It's a federal law that applies to third parties collecting on behalf of another, so not original creditors. And this is a term of art that basically means the entity, the business entity, person that issued you credit or lent you money. So for instance, if you had a Capital One credit card, Capital One is your original creditor. That's who you directly owe the money to. Now, who is a third party collecting on behalf of another? And that could be a collection agency, a debt buyer, who's otherwise known as a person who buys bad debts, buys them up for pennies on the dollar. It could be an attorney for an original creditor or a debt buyer. So for example, the entity that bought your Capital One account could be that entity's lawyer. So in Nevada, something really important to note is that the Federal Fair Debt Collection Practices Act applies to payday and title lenders who would otherwise be considered original creditors and not subject to the Fair Debt Collection Practices Act. So in plain English, our law here in Nevada makes payday and title lenders subject to the federal law. Even though these are not third-party debt collectors or debt buyers, they're original creditors, they're still subject under our state law to the Fair Debt Collection Practices Act. And this is a good thing because the Fair Debt Collection Practices Act is pretty broad. It prohibits all manner of unfair and abusive debt collection practices, so it ensures consumer protection. So I'm just going to give you a few examples of things that are prohibited under the Fair Debt Collection Practices Act. So they can't call you in the middle of the night. They can't call you between 9 p.m. and 8 a.m., presumably the hours when most people are asleep. They can't communicate with third parties about the debt, so they can't call mom, dad, brother, sister, husband, wife, neighbors, friends, employers. They can't talk to your employer. They can't talk to the company you work for, or HR department. They can only communicate with you about your debt. They also can't threaten to take legal action that can't be taken, including but not limited to threats of incarceration for non-payment. So in other words, if they say, I'm going to throw you in jail if you don't pay your debt, they can't do that. So that would be against the Fair Debt Collection Practices Act. They also can't use abusive or unfair means to collect a debt. So commonly swearing at borrowers, threatening harm to person or property, threatening to harm someone's pets. They can't do any of these abusive or unfair means. They also can't contact a borrower following the receipt of a cease communication letter. So if you're being harassed by a debt collector and you send them a letter that says, please stop communicating with me, and if they continue to communicate with you, that is a violation of the federal law. So what is a cease communication letter? So a cease communication letter is basically a letter that you send to a debt collector, essentially saying, stop bothering me. So first you need to identify the caller. We're assuming that you're getting a lot of unwanted phone calls from this debt collector. Google the telephone number, ask the caller to identify him or herself. Where are you calling from? What's your name? What's your ID number? Or check your credit report. Step 2, we have a form cease communication letter on our website at www.lacsn.org, or you can draft your own. But you can just use the form cease communication letter. This has all the language in it that you'll need to tell a debt collector, hey, stop contacting me. Step 3, you would send the cease communication letter. We recommend sending it by certified mail so that you have a record of sending it. Return receipt requested. This will make the other side sign for it. At the very least, we know that return receipt can be a financial hardship for some of our clients. So at least make a photocopy of the completed letter and the envelope that you sent it in, just in case you ever have to use this in a court of law or for official purposes, you have a copy. Step 4, harassing phone calls should stop within 2 to 3 business days. So if the phone calls persist, we recommend that you make a log of the date, time, identity of the caller, and especially if abusive things are being said to you over the phone. And then you can contact us here at the Legal Aid Center of Southern Nevada to discuss your legal options. And this is a sample call log that you can use. So one of these is available on our website as well. Okay, here you can see we have a sample cease communication letter that you can send to a payday or title lender that is harassing you, or that you just want to get more information about the debt from. So the letter starts off, pursuant to Nevada Revised Statute 604A.5014, this letter shall serve as notice to you to cease communication with me regarding the above referenced debt. So you're putting the title or payday lender on notice that you want them to cease communication. And that's generally because they would have been harassing you and it's just gotten to a point where it's very annoying and you want them to stop. The second part of this letter asks them to consider the account in default. This is if you're just unable to pay back the loan. You want them to consider the loan in default as of the date of the letter, and as such, pursuant to the statute, drop the interest rate to prime plus 10%. As we talked about in an earlier slide, this lower interest rate is what they can charge after default. So you want them to drop the interest rate now that you are in default. And finally, you are asking them to provide written validation of the debt and that you're letting them know that you're disputing all or part of this debt. And this will allow them to give you contracts and receipts, billing records, payment histories, and notices to the address that you specify. Okay, what happens if a lender violates NRS 604A? So that's the payday and title lending statute here in Nevada. So for willful violations, the loan will be void, assuming that the borrower proves this in court. The loan is void. The lender cannot collect, receive, or retain any principal, interest, or other fees. Now, if it's an unlicensed lender, all of these lenders are regulated through our Financial Institutions Division. If they're unlicensed, they're subject to fines, to administrative fines and penalties. A consumer can bring a civil action in a Nevada court for certain violations of this statute. And if they win, if they're the prevailing party, they can receive actual and consequential damages. This essentially means money that they are owed because of the violation. Punitive damages, this is to punish and deter the bad acts of the lender. Reasonable attorney's fees and costs, assuming that they hire an attorney. And any other legal or equitable relief that the court deems appropriate. They can also get statutory damages of $1,000 if the lender commits a violation knowingly. Now I'd like to talk about remedies for NRS 604A violations. So a lot of our consumers will ask, what happens if a payday or title lender violates the state law or violates the federal law through our state law? So we're going to talk a little bit about how that happens and what the borrower's remedies might be. So remember we talked about in an earlier slide the Federal Fair Debt Collection Practices Act. And so payday and title lenders are subject to that law through our state law. So if a lender violates the Federal Fair Debt Collection Practices Act via our state law, the borrower's remedies are under the state law, not the federal. The borrower can still sue entities under the Federal Fair Debt Collection Practices Act. They just can't sue the original creditor. They can't sue the payday or title lender. That would be under the state law. So let me give you an example that might make this a little bit more concrete. So let's say that Ad Astra Recovery Services, which is Rapid Cash's debt collector, or their debt collection wing, is trying to collect too much debt from you, or debt that you don't owe. That's a violation of the Fair Debt Collection Practices Act. The borrower, you as the borrower, may have a federal Fair Debt Collection Practices claim against Ad Astra, not Rapid Cash. Now, if Rapid Cash itself is violating the Federal Fair Debt Collection Practices Act, you may have a remedy through the state law. So if you're having questions or trouble with any of these claims or just want to learn more, you can feel free to visit us at Legal Aid Center of Southern Nevada. We have walk-in hours Monday through Thursday, 9 to 4, and come see us and ask us your questions. And one final point about this is the Fair Debt Collection Practices Act provides for statutory damages of up to $1,000 if you prevail in court. Okay, so some consumer tips. We recommend that you minimize your use of short-term lending. Get everything in writing. The only way to prove something happened is to have it documented. Letters, voicemails, emails, this could even be text messages. If you're sending a letter, make a copy of the signed letter and the envelope just so that you have it for your records. Mail letters certified, return receipt requested. That'll cause the other side to have to sign. If that's too expensive, try at least to send it certified, but always keep a copy of the signed letter in the envelope. Again, save all your documents, including letters, contracts, and receipts. Check your mail, check your email, ask questions. Make sure you understand your obligations before you finalize any loan with a lender. Regularly check your credit reports. You can access them for free every week on annualcreditreport.com, and that is a service that will not charge you for your credit reports. And yes, you really can access them for free every week, and that's been a privilege that they've offered to consumers since the pandemic. Okay, so more consumer tips. If you default on a short-term loan account for which you have given authorization to make an automatic debit from your checking or savings account, that's, in other words, if you've given the lender permission to take directly from your bank account automatically, you might wish to close the account before you default and open another account at a different financial institution. And in this way, you avoid a double return check fee. So the lender may only charge one fee if the check is returned due to account closure. If you have been sued, it's important to file a written answer within 20 days, and that would be in our state justice courts, or 21 days, our state district courts, of the date on which you were served with the summons and complaint. So if you're being sued by a payday or title lender, they will have to deliver the summons and complaint to you personally. This might be through a private process server, through the constable, and then at that point, the clock begins to run for how long you have to file an answer with your defenses. So that's, again, 20 days in justice court or 21 days in district court. If you don't file an answer, the lender can obtain a default judgment against you, meaning that they just win by default because you didn't file anything to defend yourself. You should always answer and or go to court to ensure that the lender does not add fees that you do not owe. If you're being harassed by a lender, consider sending a cease communication letter. Also, if you feel that the lender has violated the law, consider making a complaint to our Nevada Financial Institutions Division. This is an online complaint form. Finally, we don't recommend that you take out loans over the internet. The law is unclear. We don't know, what law that these loans are subject to. They may fall outside the protections of Nevada state law. It's just very risky to take out loans over the internet. If you're considering bankruptcy, we also offer a class, the Bankruptcy Community Service class, here at Legal Aid Center. At the class, you can obtain an application for a pro bono, that's a free attorney through our office if you decide to file for bankruptcy. If this is something you have a lot of debt and you're considering bankruptcy, come to our class and just learn about the common types of bankruptcy, some of the the essential and important information that you need to know if you're going to file bankruptcy, and also how to apply for a pro bono attorney if you are unable to afford an attorney. It's not recommended that you hire a non-attorney bankruptcy petition preparer. An unknowledgeable petition preparer can often make a bad situation worse and does not have the same accountability as a licensed attorney. It's not recommended that you use a petition preparer for any legal service. Look for free services before you pay somebody to help you, or come and see us and we can give you some community resources or some guidance. If you have utilized a bankruptcy petition preparer or any type of petition preparer and you're unhappy with the services provided, please contact Legal Aid Center of Southern Nevada and we'll see if we can help you. So we can help. If you think you need further assistance with your legal matter, particularly payday or title loans, you can consult with an attorney or contact us. You can come to our Civil Law Self-Help Center. They are located on at the Regional Justice Center at 200 Lewis Avenue. That's down at the big courthouse on Lewis Avenue. They're also available on the web, civillawselfhelpcenter.org. And although they can't give legal advice, they can give legal information and help you fill out forms. They have a whole suite of free forms if you need to file anything in court. Or you can come and see us at our walk-in hours at our main office, Legal Aid Center of Southern Nevada, here at 725 East Charleston Boulevard. And our walk-in hours are Monday through Thursday, 9 a.m. to 4 p.m. Thank you so much for attending our Payday and Title Loan class. I hope you've learned a little bit more about short-term lending and your rights as a borrower and what lenders can and cannot do under the law. And we are delighted to have had you join us today. Feel free to check out our website, lacsn.org, for a full schedule of other classes. Thank you and have a wonderful day.